Hello everyone, welcome back to our channel Legal Nexus. Ever handed over something valuable as security for a loan? That is called a pledge, and it is more than just a promise. In this video, we'll explore what a pledge really means in legal terms, how it works, the rights of the pawner and pawnee, and why it is so important in the world of short transaction. Whether you're a law student preparing for exams or just curious about how collateral works in real life, you're in the right place. Let's break it down simply and clearly. A pledge is also known as pawn, is a special type of bailment where goods are given as security for the repayment of a loan or the performance of a promise. In this agreement, the person giving the goods is called pawner and the person receiving them is known as pawnee. The pawnee holds on to the goods until the loan is repaid or the promise is fulfilled. Once that happens, the goods are returned to the pawner. Essentials of valid pledge. To understand how a pledge works, it is important to know its essential features. Delivery of goods. The goods being pledged must be delivered to the pawnee. This can be physical or constructive delivery like handing over the key or documents. Valid contract. Even though a pledge is a special type of a contract, it does still need to meet all the basic requirements of valid contract under the Indian Contract Act 1872. The third essential point is right of the pawnee. The pawnee only gets possession of the goods, not ownership. The pawner still remains the legal owner. Timing of delivery. The delivery of goods and the loan amount doesn't have to happen at the same time. A pledge can be even made after the loan is given. Duties of the pawner. Pay the debt and interest must repay the debt with interest and necessary expenses to reclaim the goods, compensate expenses, responsible for ordinary and extraordinary expenses incurred by the pawnee for preservation, disclose the fault, must reveal any defects or faults in the goods that could harm the pawnee. Rights of the pawner. Redeem pledged goods. Right to redeem goods at any time before the actual sale, even after default, by paying the required amount. Receive surplus. Entitled to any surplus amount if the pawnee sells the goods and really realize more than the earned amount. Profit from goods. If pawnee earns profit from the goods, it must be returned to the pawner. Duty of the pawnee. Take reasonable care. Must look after the pledged good as returned person would look after their own goods. Not use goods unauthorizedly. Cannot use pledged goods without permission. Unauthorized use makes the pawnee liable. Return goods. Must return the goods after the debtor is paid or the promise is fulfilled. Keep goods separated. Should not mix pledged goods with his own goods. Right of the pawnee. Right to retain. Can retain goods until full payment of debt or interest and preservation expenses. Right to recover extraordinary expenses. Can claim but not retain goods for such expenses. Right to sell. May sell goods if the pawner defaults after reasonable notice. Surplus returned to pawner. Shortfall can be claimed from pawner. Right against third parties. Can sue a third party who wrongfully deprives him of possession. Pledge and bailment. Though both are involves transfer of goods, there are some difference also. Bailment refers to the transfer of goods from one person to another for a specific purpose, while a pledges the transfer of goods gives as security for the repayment of a debt. Bailment is defined under Section 148 of the Indian Contract Act 1872, whereas pledge is covered under Section 172 of the same Act. In bailment, the person who delivers the goods is called the bailer, and the person who receives the is known as bailee. In the case of pledge, the person delivering the good is referred as to the pledger or pawner, and the person receiving the goods is called the pledgee or Pawnee. In the case of Lalan Prasad versus Rahmat Ali and Anna, in this case the plaintiff advanced Indian rupees 20,000 to the defendant against a promissory note and a receipt. An agreement was signed by both the parties where the defendant agreed to pledge his horoscopes and collateral against his debt. As per their agreement, the defendant had to deliver the horoscopes to the appellant and the goods would remain in his custody. The plaintiff filed a lawsuit claiming that the above-mentioned goods were never delivered to be in his custody and therefore this agreement cannot be considered as a contract of pledge. He claimed that he was entitled to recover the amount loaned by him. The movie Mercantile Bank Limited and Anna versus Union of India 1965. In this case, a firm operating in Mumbai entrusted their goods worth 35,500 to railways for its delivery to Delhi. The firm got their receipt for these goods from the railways. In order to get an advance of Indian rupees 20,000 from the plaintiff, the firm pledged these receipts as collateral for the same. The goods were lost by the railways and they offered to compensate with certain parcels to the plaintiff. The plaintiff rejected this and claimed that those were in the goods that were pledged to them. The plaintiff had sued the railways to recover Indian rupees 35,500 against the value of goods pledged to them, including the damages. To sum up it, a pledge is a bailment of goods as a security for repayment of a debt or performance of a promise. The pawner gives the goods, the pawnee holds them, and both parties have specific rights and duties under the law. Whether it is in banking, business, or personal transaction, understanding how a pledge works can help us protect your interest. If you found this video interesting, please don't forget to like, share, and subscribe.